While now is successful in raising awareness to bring cases pertaining to women's rights and issues, one cannot use them as a basis for judging the whole feminist movement. As one feminist recounted, the women's movement is a non-hierarchical one. It does things collectively and experimentally. While many lauded the non-hierarchical nature of the women's rights movement, this also gave rise to conflict within the movement. The older, more mainstream movement, exemplified by Betty Friedan, seemed to stand in opposition to the more radical and younger movement, exemplified by Gloria Steinem. Despite these divisions, they did cooperate, and there was a lot of unity and solidarity in terms of passing some very radical and very far-reaching legislation. And they came together on one piece of legislation in particular, called the Equal Rights Amendment. In the early months of 1972, Congress recommended to the state legislatures of this country to pass an amendment adding the sentence, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex." This was the Equal Rights Amendment. It had been proposed many times since the 1920s, but in the 1970s, it seemed so close to reality. However, many people felt that this went too far. Phyllis Schlafly, a devout Christian and ardent conservative, championed the movement to stop the ERA. While the women's rights movement was able to get the ERA ratified in 35 state legislatures, Schlafly's movement is able to prevent the ERA from being ratified and getting the last 3. The solid decade of progress for the women's rights movement, through the inclusion of women in Section 7 of the Civil Rights Act, 1964, and the passage of the Equal Pay Act, did not stall because of the failure of the ERA. It kept moving, like a locomotive that had just lost one train car. While the battle for full legal equality in the law was being fought, reproductive rights were proliferating. For generations, a lack of contraceptives almost forced women to have children and to sideline any other dreams. However, in 1960, a contraceptive pill came into use. Its ubiquity is characterized by this colloquial name, the pill. In only 5 years, 6.5 million American women were on the pill. Furthermore, in the landmark case, Griswold v. Connecticut, Supreme Court ruled that one has a constitutional right to contraceptives, as the states legislating against that will be legislating against marital privacy. They established that based off the 1st, 4th, 6th, and 9th Amendments, stating that they all created a penumbra of privacy. This creation of a right, while not liked by conservatives, is akin to the creation of the freedom to contract right in the Lochner v. United States case, which, for better or worse, conservatives seem to love with all their right-to-work legislation they're pushing through. Only a few states like Connecticut, though, had their laws ruled unconstitutional by Griswold v. Connecticut. However, just 8 years later, another case would come to the Supreme Court, Roe v. Wade, which would make huge, huge ripples. In 1970, Norma McCorvey became pregnant for the 3rd time. Living in poverty and squalor, she'd been raped twice before and brought 2 children into the world, who she subsequently gave for adoption. And in 1970, she decided to seek an abortion under the rape exception. However, there was no rape exception in the law, and the only allowances of abortion in Texas law was if the life of the mother was in danger. With the help of her attorney, Sarah Weddington, she sued the state of Texas. In December of 1971, the Supreme Court heard the case. Due to technical difficulties, Sarah Weddington's inability to find the constitutional hook according to Oyez, the case was re-argued in October of 1972 and was finally decided on January 22nd, 1973. In a 7-2 decision, Supreme Court ruled the state cannot legislate against abortion, as there is a constitutional right created by the penumbras of privacy for abortion. This decision, while widely controversial, has not been overturned since.